Welcome, everyone, and thank you for attending. Any questions you have can be asked in the Q&A pane in your WebEx event control panel. Today's presentation will be recorded. If you have any objection, you may disconnect at this time. The recording will be available on demand within 48 hours of the live program. I will now turn it over to Henry. You may begin.
Thank you, Kelly. Good afternoon, SHRMLI, Long Island. It is Friday. Always a good thing. Friday, September 25th. I am coming to you from the Long Island office today, not home, which is, I guess, good and bad. I do want to just take about 15 to 20 very quick seconds there were several people who reached out to me after last month's August webinar, just over the personal stuff dealing with my dog, which I greatly appreciate, and it means a heck of a lot to me that people actually took the time to care, and that they don't just look at this as a boring 20-minute lecture on the law, even though that's what I kind of look at it as, but I apologize. But anyway, that's all I'll say about that, but I do thank everybody that reached out. It does mean a lot, so I appreciate it. So on to greener pastures. Today, we are going to talk about a little bit of a mishmash of stuff. I went with I thought, a very festive seasonal title. What's good is next month we will be restarting the Long Island Breakfast Series. For those of you that attend, it will still be by webinar. You're going to, unfortunately, have to listen to me twice in that week, as I will be co-presenting in that one with Craig Roberts and Tim Dominic, where we're going to kind of give you a rundown of everything that's been going on the last several months and what's to come. And then you'll get to hear me on this lovely webinar. I don't know how the days work out, but either the next day or the following week. So today, and I could tell you most of what I've been getting calls on the last week is New York paid sick leave. For those of you that were on the webinar, I think back in April, I spoke about it at length, at least with what we know currently. Surprisingly, unsurprisingly, not much has changed since then. So what I'm going to spend most of my time on today, though, is the changes following the Department of Labor, U.S. Department of Labor's new rule on the Families First law, which we all know and love as the FFCRA. I will talk a little bit about paid sick leave at the end, but and I'll talk a little bit about voting leave as well, but let me just stress this. Paid sick leave is important. I'm aware that most companies offer some form of something, whether it be PTO time, paid sick time, vacation time, whatever it may be. You do have to do a little bit of work to come into compliance with the state law if you don't offer enough, or if you don't offer it for the right reasons, or at the right accrual rate. There's a lot we don't know. I could give you the same lecture I gave in April, but there is some that we do know, and what we do know is that accruals must start on September 30th. So if you are one of the employers who offers no time off because you are in Nassau or Suffolk and you don't have any statutory requirement to offer paid time off, there's no legal requirement for vacation time or sick time. You got FMLA if you're big enough, and you got paid family leave. That's it. If you don't offer time, you got a little bit of work to do before, I guess 30th is Wednesday, before Wednesday of next week. So if you're not sure, reach out to whoever you work with. If it's me, if it's somebody at Jackson Lewis, reach out to us. If it's other counsel, whatever it may be, and let's get you where you need to be, at least based on what we know right now. So a little bit of a background. As I said, we got the new FFCRA temporary rule from the Department of Labor, some new FAQs following this court decision that I think I spoke about last month, where the Southern District of New York knocked the Department of Labor's interpretation and temporary rule regarding FFCRA with intermittent leave, notice requirements, healthcare provider definition, whether people who are on furlough can get FFCRA benefits. That's all been clarified now that the court spoke on it. Now the DOL responded. For any movie buffs, you'll see a little bit of a reference to something in here. I try to have fun with this so everybody enjoys it. I don't know if I'm succeeding, but 3.5 years in, I'm still trying. New York paid sick leave, we'll get there. And the voting leave, it's something you might already know, but I want to give you a little bit of a reminder rather than telling you in late October that you have to do something within the next 2 weeks. So Southern District of New York speaks on FFCRA, New Hope. Here's where the movie reference comes in, so pay attention. Was it a New Hope? Not really. The Southern District made it a little bit harder for employers to manage FFCRA because it gave employees temporarily more rights. The main things that changed were the definition of who qualifies for the healthcare provider exemption, the exclusion from benefits of employees whose employers do not have work for them. That's furloughed people, whether or not they can get benefits. The court seemed to suggest that people on furlough could get benefits. The DOL has since spoken out on that, so we'll get to that in a second. The requirement that employees secure consent for intermittent leave, so that's a big one. Employers do not have to give intermittent leave if they didn't want to. The Southern District of New York made it appear that you had to give it even if you didn't want to as the employer, that employer consent was not necessary. And the requirement that documentation be provided before taking leave. The Southern District said, you could take leave and give the documentation later. Employer, you cannot hold up the employee taking the FFCRA time just because you didn't get the documentation. So the Department of Labor strikes back. Again, play along with me. Hopefully you get the movie reference. So the Department of Labor strikes back. Following the Southern District ruling, calling several provisions into question, they came out with a new temporary rule, a nice and short 53-page rule. And what changed? So not a lot. They actually reaffirmed some things, which is good for employers. They reaffirmed that employees may take FFCRA leave only when work is actually available to them. So if you still have people on furlough, they cannot, now the DOL has come out and stated again, they cannot collect FFCRA benefits because the reason they are not working is because there is no work available. It is not because they have an FFCRA qualifying reason. So key distinction. They reaffirm that employees must have their employer's approval to take intermittent FFCRA leave. Also good. I'm going to break that down a little bit further in a couple of slides, but that's another plus for employers. We now have say as an employer over the use of intermittent leave, whereas the court 6 weeks earlier suggested that an employee can take intermittent leave. And our advice on these issues was changing by the day, not because we weren't sure. We knew exactly what was going on. It was the court and the Department of Labor that weren't sure. So trying to interpret something that's been as fluid as this is always a challenge. But, if this mattered to your business, your answer in July might have been different than your answer in August. That might have been different than your answer in September. That's how fast this is moving. Revised definition of healthcare provider. I don't know how many people on this call this will be relevant for. I'll touch on it a little bit quickly just in case you are in the healthcare field or have healthcare workers. But it basically, this one was a bad one for employers. It restricted who you can take the exemption for. So basically there's an exemption for emergency responders and healthcare providers that you don't have to give them FFCRA leave if they qualify as part of the exemption. The reason, the thinking was during this pandemic, those are the people that we need at work the most. And the last thing we could do is afford to give them 2 weeks out of work, or due to school closures, possibly 12 weeks out of work. So an employer could exempt them. It was a very broad strokes exemption. It was anybody that worked there. So arguably your receptionist at your nursing home could not take FFCRA benefits because they fit under healthcare provider. What the court did is said it's too broad, fix it. What the Department of Labor did is basically restricted it to the FMLA definition, where you focus on the actual employee, what the employee does. So you're not going to exclude your HR professional. They can get FFCRA benefits, but your nurses, they can be exempted because we need them in the healthcare system. The HR professionals, the IT professionals, the payroll professionals, you will take the benefits. You're not essential to the care of the people in the healthcare system. It'll lastly clarify that employees must provide employers with documentation as soon as possible. So that's kind of a little bit of an annoyance, but shouldn't be a major one. That changed as well. Now you cannot require the employee cannot require the employee to give documentation prior to them taking leave. They just have to do it as soon as practicable. So the work availability request, this one we can move through quickly. Again, leave is only available if a qualifying reason was the but-for cause, fancy legal word, the but-for cause of the employee's inability to work. If it is not the but-for cause, the reason for leave, if they are, again, not working because your company has unfortunately faced a downturn in business and you furloughed a bunch of folks, then they cannot pick up these FFCRA benefits because the reason they are not working is the downturn in business, not because they have a qualifying reason for leave. intermittent leave. So may only be taken with the approval of the employer, but there is a difference between intermittent leave and consecutive requests for leave. So I just wanted to break this down with some quotes that came from the Department of Labor because I think it's helpful. The employer approval condition would not apply to employees who take FFCRA leave in full-day increments to care for their children whose schools are operating on an alternate day or other hybrid attendance basis, because such leave would not be intermittent. In an alternate day or other hybrid attendance schedule implemented due to COVID, the school is physically closed with respect to certain students on particular days as determined and directed by the school, not the employee. So it's not intermittent leave because the employee's not picking and choosing, oh, I'll take Monday, I'll take Friday, I'll take Wednesday, Tuesday. There's a schedule. So we know what's happening there. It's not intermittent. Each day of school closure constitutes a separate reason for FFCRA leave that ends when the school opens again for the particular student. The employee may take leave due to a school closure until that qualifying reason ends, that is, the school opened the next day, and then take leave again when a new qualifying reason arises. School closes again the day after that. So that's for those of you with children or the employees with children where school is, let's say, open on Monday, Wednesday, Friday, and you're teaching them from home on Tuesday, or they're signing in with their iPad or their Surface on Tuesday and Thursday. That's not the intermittent leave request. That's just a continuous leave with a schedule. We have a schedule there. However, if the school is closed for some period and then the employee wishes to take leave only for certain portions of that period for reasons other than the school's in-person instruction schedule, this would constitute a request for intermittent leave that would require his or her employer's agreement. So that's basically saying what I said earlier, where I really randomly want this Monday, Thursday, next Tuesday, Friday, then the following Wednesday, Monday. Those are not based on school schedules. That's a traditional intermittent leave request. Those are the ones where you do need the employer's consent. So as the employer, you can deny such request. So I spoke about this earlier. Don't get scared by the amount of type here just because this becomes available. I wanted to make sure you had all the information available, so I wanted to give it to you. Healthcare provider, again, for those that are in this field or have this come up, who can now be excluded from receiving FFCRA benefits. If you were the employer, who can you kind of screen out? Because again, before the Southern District of New York ruling, it was based on the business. If you were in the healthcare field, you could screen out all of your employees. Nobody gets FFCRA benefits. Southern District said, no, that's too broad. Department of Labor came back and said, okay, we'll follow the FMLA definition where it's based on the person's job duties, not just the employer. So that's what it's a more employee-specific analysis than it is employer-specific. So the people who are excluded are exactly who you would expect to be excluded. Or who you could exclude if you want: doctors, podiatrists, dentists, psychologists, nurse practitioners, anybody who is capable of this. The fifth sub-bullet point is the kind of catch-all. Anybody who's capable of providing healthcare services. You got x-ray techs, preventative services, or other services that are integrated with and necessary to the provision of patient care, and if not provided, would adversely impact patient care. So people who are involved with bathing, dressing, hand feeding, really geared towards the healthcare field. It doesn't really matter outside that field unless you happen to have healthcare workers as part of your business, then perhaps you can screen them out from getting these benefits. Under that last catch-all, you got nurses, assistants, employees providing services under the supervision, order, or direction of, or providing direct assistance to a person such as a doctor or a podiatrist or a dentist or a psychologist. But again, it's employees who are integrated into and necessary to the provision of healthcare services. Who doesn't it include, which I think is important for a lot of employers because they want to know maybe people that they were telling back in April, May, June, July, oh, you can't get these benefits, we're exempt, and now you have to give it to them. And there's really no clear answer on retroactivity. However, it is our position that these changes are not retroactive. They are as of September 16th moving forward. But again, that's not written in stone. That's just our interpretation of what currently exists from the Department of Labor. But who is not included? Who must you give the benefits to? You cannot exempt them from FFCRA coverage. IT, building maintenance staff, human resources, cooks, food service workers, records managers, consultants, billers. How you can tell me that a food service worker is not essential to patient care? If I don't feed the patients, I don't know really what's going to happen to them. I don't know, but I didn't write the rule, so this is what we're stuck with. New York paid. So those are the changes on the FFCRA. Again, not anything too earth-shattering. Anytime you see the DOL reaffirming things, it's always good. So we got a lot of that. The biggest changes are when you're going to get the documentation, the healthcare provider exemption, but otherwise, really, the intermittent leave, you could still deny it in most scenarios if you have to, and you don't have to give the benefits to people on furlough. So a lot of what stayed the same was good. New York paid sick leave, as I said, starts next week. Accruals start on Wednesday under this law. The accrual rate is 1 hour for every 30 hours worked. If you have operations in New York City where you're providing New York City earned sick time or paid sick leave, whatever you want to call it, same accrual rate, 1 hour for every 30 hours worked. So ultimately, if I am a full-time, quote-unquote, 40-hour-a-week employee, if I work, after I work for 3 weeks, so 120 hours worked, I will have 4 hours of paid sick time under this new law. So time will add up fast. And then technically starting January 1, I am able to use that sick time that I accrued or earned. There is next to no guidance right now other than the statute itself, which is about 5 or so double-spaced pages. So we don't have a ton of information, but there is next to no guidance on what kind of documentation you can request, what kind of notice you can request. The way the law reads right now is if I have the time accrued, I can use it, period, if I have one of these qualifying reasons. How much of it can I use? Well, this 40 hours or 56 hours will depend on the size of your company. If you have more than 100 employees, it's 56 hours. If you have less than 100, it is 40 hours. If you are super small and you're talking less than 5 employees, then it's just unpaid sick time, depending on your revenue. If you are less than 5 employees but pulling in over $1 million in revenue in the prior tax year, then you're given 40 hours of paid leave, paid sick leave. Can you put it in a PTO policy, or do you have to have an explicit New York State paid sick leave policy? You can put it in a PTO policy as long as it matches the usage, accrual, and carryover requirements of the law. So even if you have an existing PTO policy where you give 30 days off a year, doesn't necessarily mean it's going to be compliant with New York State's requirements for their paid sick leave law. So have it reviewed, have it looked at. Some tweaks might be needed, whether it be for qualifying reasons or carryover, whatever it may be. But I strongly recommend you get those policies looked at. January 1, 2021 is when everything here becomes fully effective. The usage, carryover, everything. The accruals do start, though, next week. What does it cover? Employee's own condition, family member's condition. Family member is very broad, more broad than the definition under the paid family leave law. It includes siblings. It includes parent-in-laws, or your in-laws, which the PFL does include. It includes child of your spouse, if it's not, not the same. If it's basically a child that you kind of second marriage, possibly, it includes that. It is a very broad definition. It also covers safe leave, which if you're in New York City, you know about this already, but safe leave is basically things related to domestic violence, sexual abuse, sexual assault. It covers everything from having to go to court, having to deal with the police, having to deal with counselors and doctors relating to domestic violence issues. All that is covered as well. Again, regulations, guidance, we're waiting, unfortunately, not surprisingly, but unfortunately we have nothing right now beyond the law. So we're all doing a little bit of guessing, but there is some work you could do to get ready and be better situated when this does come, when the guidance does come out there. You could just do some refining rather than doing it all from scratch. Last thing we'll talk about, voting leave, and I only really bring this up because there was a change earlier this year to revert back to pre-2019 rules. So last year, 2019, it went up to, you get 3 hours of paid time off, which was shocking, and people got annoyed and yelled at us, even though we don't write the laws. But now it's back to what it was pre-2019. You get 2 hours of paid time off if you do not have 4 consecutive hours either before or after your shift to vote. So I believe in New York State, polls are generally open from 6 a.m. to 9 p.m. So if somebody's shift ends at 5 o'clock, they have 4 hours after they get off, they're fine. However, if they work 9 to 6, they're only going to have 6 to 9 before, and they're going to have 6 to 9 after. They are not going to have the 4 consecutive hours for voting time. You have to give them you have to give them 2 hours of paid time off that you can designate when it happens. It could be at the beginning of the shift, at the end of the shift. You can agree to some time in the middle of the shift if you want, although that's probably a scheduling nightmare, but you could do that. The employee must give you notice if they're going to take this voting leave. They got to do it no more than 10, not less than 2 working days before the election. And lastly, you have a poster you have to put up. You can get it from council. You can get it from Google, which is a pretty good attorney sometimes. Literally, if you type in the New York voting election poster or election rights poster, you'll see a PDF from, I think it's something ny.gov. You'll see the website, but it's a one-page poster that's got to go up. If you need help with it, just again reach out to your council. But that's got to go up as well, not less than 10 days before every election, and it's got to be up through through the time the polls close. So in reality, you're probably taking it off the day after election day. That's all I got for you today. Your takeaways: review your policies on paid time off, on voting leave. Again, they might be outdated, even if you had your handbook updated last year. You got to comply with the voting leave. You got to comply with the paid sick leave. It covers everybody. Do not forget, here's my last reminder, do not forget your sexual harassment training. So a lot of companies did it based off the October deadline last year, so people's 1 year might be coming up. Get your training done. There's been no exclusions or exemptions for people because of COVID. Do it by webinar, do it virtually, whatever you got to do, get it done. Management, employee training, all of it. And then let's just make sure we get ready. I don't want to be, I hate to end on a sad note, so I'll pepper it up in a second, but make sure you get ahead of the ball for anything that might happen this fall and this winter. If we do have another outbreak, we want to make sure that our remote work policies are in line, that we have performance management in line. Don't let things fall through the cracks. It will be your worst enemy. So let's just make sure that we're prepared. So if something does happen again, like a March and April, that we know that, we've been through it once, let's fix it now. So with that, I said something happy. Fall is great, good weather. I went apple picking last weekend, so if you feel comfortable going out, apples, pumpkins, cider mills, plenty of things to do. Enjoy. I think we're supposed to have very nice weather this weekend. If you're a Jets fan, don't watch the game like me. Otherwise, everybody have a wonderful weekend. I will speak to you at the Breakfast Series in October, then this again in October, and I hope you are all staying safe and doing well, and take care and have a great day. Bye-bye, everybody.